finds that the prosecution has failed to discharge the burden of proof beyond any reasonable doubt. Accordingly, the accused person is hereby acquitted under Section 215 of the CPC. Data being a funeral procession with a casket covered with a Kenyan flag, escorted by a military officer in a ceremonial uniform, which he captioned, and I quote, "President William Ruto's body leaves Lee Funeral Home over computer system X using an X account, landlord at Vasty, with intent that the data shall be considered as authentic." The accused person denied the offense, and in its endeavor to prove the charges, the prosecution called 6 witnesses. In defense, the accused gave a sworn statement. Allow me not to go through the summary of the evidence, which was quite lengthy. I want to go straight to the issues for determination. Just a minute. So the court has considered the evidence which was adduced by the prosecution and the defense. I've also considered the closing submissions by the defense and the Law Society of Kenya. In my considered view, the issues for determination were: 1, whether the prosecution proved the impunged publication originated from or was controlled by the accused person, and 2, whether the electronic evidence relied upon was lawfully obtained and admissible. So on the first issue, under Section 22(1) of the Computer Misuse and Cybercrimes Act number 5 of 2018, it provides that a person who intentionally publishes false, misleading, or fictitious data or misinforms with the intent that the data shall be considered or acted upon as authentic with or without financial gain commits an offense. From the above provision, Section 22(1) criminalizes the intentional publication of false information through a computer system where the publisher knows the information to be false and where the publication is calculated to cause panic, chaos, or damage of reputation. In this case, while the screenshots of the impunged posts were produced, screenshots alone merely demonstrate that a publication existed. They do not establish authorship. The central question before the court is whether the accused person was positively linked as the person who published this alleged post. In this case, there was no forensic digital evidence which was produced linking the accused person to the creation and sole control or operation of the X account. Further, no data was obtained from the service provider identifying the subscriber, IP address, device, or login history associated with the accused person. The IO told the court that the X account had the accused person's personal information. In his defense, the accused conceded that his personal details were in the account since he had been tasked to manage the account. The accused, however, clarified that 3 other people had access to the account. While the accused may not have named the other individuals who had access to the account, it's straight law that in a criminal trial, the burden of proof never shifts to an accused person. It remains with the prosecution throughout the trial. The onus, therefore, was upon the prosecution to prove it was indeed the accused person who had posted the impunged post. The court has carefully scrutinized the cybercrime and digital forensic report which was produced in court as Plaintiff Exhibit 2, and in particular on page number 6 of the said report, which has the details of the impunged post subject to these proceedings. The said page clearly shows the post was done on the 13th of November 2024 at 11:15:27, the timestamp being at Nairobi. I do believe this is a very relevant fact, since from the evidence, the accused person herein resides in Eldoret. Indeed, that is where he was arrested. There was no evidence before the court that on the material day, the accused person was in Nairobi. This begs the question, if indeed the accused person was in Eldoret, how then did he post in Nairobi? Further, from the cybercrime investigation report from the Communication Authority of Kenya, that is CAK, which was produced as Plaintiff Exhibit number 8, it clearly indicated the phone number linked to the X account, that is landlord at Gabi, was. However, from the evidence, this number was not linked to the accused person. According to the witness from Safaricom, the court finds the investigators bypassed the legal safeguards due to the perceived gravity of the post involving the president. Admission of such evidence would legitimize the unconstitutional investigation methods. Constitutional rights are tested more severely in moments of public pressure, and it's precise at such moments that courts must insist on strict adherence of due process. Having excluded the unlawfully obtained evidence and finding no independent proof linking the accused person to the impunged publication, this court finds that the prosecution has failed to discharge the burden of proof beyond any reasonable doubt. Accordingly, the accused person is hereby acquitted under Section 215 of the CPC.
Yana, thank you for the much reasoned ruling that the court has rendered. I wish to thank the Law Society of Kenya and the defense team of the lawyers that are present before this court. That is Stanley Kinyanjui, Atina Swiga, myself, and Shadrach Wambui, who was at the background. We also wish to thank the state, the DPP, for prosecuting a matter that was brought that had no legs to them. But they have done a good job. And we want to thank the court, that the court has stood with the constitutional safeguards. And the court has stood, decides cases without fear of failure. As we had said, it was the only matter out of the demonstrations that has gone to judgment. And we thank the court that the court has rendered a reasoned judgment. It is only unfortunate that it is not a court of high status, because this serves as a roadmap for the DCI and the investigative officers to